My name is Susan Elsen. I'm an advocate for children and families at the Massachusetts Law Reform Institute, and I've represented domestic violence survivors in the Massachusetts family courts for 24 years. I want to lead off the next three panelists, myself and the other two panelists, talking about the department's guidance on verifying homelessness due to domestic violence. My testimony is on behalf of 23 programs and organizations which provide advocacy and services to domestic violence survivors in legal services settings, shelters, and hospital-based programs. They're all listed in my testimony, which I will be submitting. And I'm testifying on behalf of the thousands of domestic violence survivors we serve. We commend the department for accurately recognizing the many types of domestic violence behaviors that force survivors and their children out of their homes with nowhere to live. However, as we describe in detail in our written testimony, the verification requirements in the guidance are out of touch with the reality of surviving and escaping domestic violence and will shut the door to shelter for most survivors. The guidance limits acceptable verification of domestic violence to documentation from courts, police, and third-party professionals. But as my other two colleagues here will illustrate, many, if not most, survivors fleeing domestic violence don't have that documentation. We know that only about half of domestic violence incidents are reported to the police, that domestic violence is often not reported to medical providers, and that survivors often do not seek legal protection, at least until they have somewhere safe to go. The studies are cited in our written testimony. There are many reasons for this, but a primary one is that leaving an abuser is the most dangerous time for survivors. In a study of women fleeing domestic violence, 81% were stalked by their former partner, and intimate partner stalkers are extremely dangerous, even lethal. Simply put, survivors fleeing domestic violence seek safety, not documents. We've included a number of specific recommendations in our written testimony, but our single most important recommendation, without which the others are virtually meaningless, is that the department needs to accept the only verification that most domestic violence survivors are able to provide: self-declaration of their circumstances. Otherwise, the Commonwealth cannot claim to be protecting homeless domestic violence survivors. In addition, we know that survivors talk to friends, family, and others whom they turn to for help more often than to professionals. For this reason, DHCD needs to accept the statements of those friends, family members, and others who have knowledge of the survivor's circumstances. There are other issues that are very serious that are addressed in our written testimony. I urge you to take a look at that. But we urge you to make these changes, as well as the others in our written testimony, to protect domestic violence survivors and their children who face the double dangers of living on the street and being tracked down by their abusers from whom they fled. Thank you.